Hello friends, how are you? Welcome to Module 4, which is financing, mortgages, all that kind of good stuff. And I'm going to just jump right into the presentation. And actually first I'm just going to start the chat. And what I'd like you to do is when you are watching to please just say hello. So I'm just going to say, please say hello. When I ask you questions, I'd like it if you would answer in the chat or email us or text us or the chat roll, okay? So that we can know that you are here, okay? It's one of the ways that we know that you're live with us is by tracking it. So I really appreciate it. All right, let's put on these little glasses and see what we can find here. Okay, so. All right, we're gonna just dig in. Are you ready? So we're going to talk about taxes, liens, and mortgages. The first will be the unit that is on, okay, so I got my colors off a little bit, there we go, is on real estate taxes and other liens. And how I'd like you to maximize this unit is I'd like you to have your book open to that unit, and I'd like you to have your recorder, and that would be your iPhone, your voice command, whatever it is, ready to go, so that you can stop, you can listen, you can keep it going. Okay, record your progress as you go, and then use the audio later for review. Okay, all right. So then, if you have any questions, we have the live chat open 9 to 9, or you can email us. All right, we'll be there during each. So real estate taxes and other liens. The ownership of real estate is subject to certain obligations imposed by state and local governments, usually in the form of taxes that become a lien against the property. A creditor or a court can also place a claim against a property to secure payment for a debt or other obligation. So our objectives in this unit are to describe the characteristics of statutory and equitable liens, describe and explain general taxes and special assessment taxes, describe and explain real property liens, including judgments and taxes, as well as protection and limitations they offer the respective parties. All right, so these are the terms, but since we're gonna go through the definitions, what I'm gonna do right now is I'm just going to scoot right through them. Now, when you go back and replay this later, if you wanna go and read through the glossary and get your definitions out there, by all means, please do. So the first is ad valorem tax, and that is a tax levied according to value, generally used to refer to real estate tax. It's also called a general tax. Assessed value, the value set on property for taxation purposes. Assessment, the imposition of a tax, charge, or levy, usually according to established rates. Assessment equalization factor, a factor, which is a number, by which the assessed value of a property is multiplied to arrive at a value for the property that is in line with the statewide tax assessments. The ad valorem tax would be based on the suggested value. An equalization factor may be applied to raise or lower assessments in a particular district or county. Okay, so for us, what we see in Massachusetts is generally at 100%, okay? Certificate of sale. The document generally given to the purchaser at a tax foreclosure sale. A certificate of sale does not convey title. Normally, it is an instrument certifying that the holder received title to the property after the redemption period passed and that the holder paid the property taxes for that interim period. Cloud on title. Any document, claim, unreleased lien, or encumbrance that may impair the title to real property or make the title doubtful, usually revealed by a title search and removed by either a quitclaim deed or a suit to quiet title. Okay, so when we're getting ready to sell the properties, if there's a cloud on the title, that generally means that we're going to have an extension or some sort of challenge to keep that deal together. Confession of judgment clause. Permits judgment to be entered against a debtor without creditors having to institute legal proceedings. Delinquent taxes. Taxes that are unpaid and past due. Equalization, the raising or lowering of assessed values for tax purposes in a particular county or taxing district to make them equal to assessments in other counties or districts. Equalization factor. A factor, which is a number by which the assessed value of a property is multiplied to arrive at a value for the property that is in line with statewide tax assessments. The ad valorem tax would be based on this adjusted value. Equitable right of redemption. The right of a defaulted property owner to recover the property before its sale by paying the appropriate fees and charges. Estate tax. Federal tax on a decedent's real and personal property. General lien. The right of a creditor to have all of the debt's property, both real and personal, sold to satisfy a debt. General real estate tax. A tax that is made up of the taxes levied on the real estate by government agencies and municipalities. Inheritance taxes. State-imposed taxes on a decedent's real and personal property. Internal Revenue Service tax lien. A lien charged by the Internal Revenue Service for non-payment of income taxes. Involuntary lien. A lien placed on the property without the consent of the property owner. Okay, so sometimes they're voluntary. That would be when you knew that they were coming and that you had said, for whatever reason, the mortgage is a voluntary lien, right? An involuntary lien would be like a credit card that you didn't pay, for example. Judgment. The formal decision of a court upon the respective rights and claims of the parties to an action or suit. After a judgment has been entered and recorded with a county recorder, it usually becomes a general lien on the property of the defendant. Okay? Junior lien. An obligation such as a second mortgage that is subordinate in right or lien priority to an existing lien on the same property. Okay, so you've got generally the primary lien on a property would in fact be the mortgage, right? Most of the time. Levy, to assess, to seize or collect. To levy a tax is to assess a property and set the rate of taxation. To levy an execution is to officially seize the property of a person in order to satisfy an obligation. A lien is a right given by law to certain creditors to have their debts paid out of the property of a defaulting debtor, usually by means of court sale. Mechanics lien. A statutory lien created in favor of contractors, laborers, material suppliers, and others who have performed work or furnished materials in the erection or repair of a building. Mill. 1/10 of 1 cent. Some states use a mill rate to compute real estate taxes. For example, a rate of 52 mills would indicate a tax of 0.052. Okay, so that would be 5.2 cents, right? For each dollar of assessed valuation of a property. So again, it's a lot of times what the town will use when they're talking about the rate. They'll say what the mill rate is. All right, a mortgage lien is a lien or charge on a mortgage of a mortgagor that secures the underlying debt obligation. Olty lien, a lien created by the order of the court to make an equitable partition of the property when otherwise an agreeable partition is impossible or impractical. For example, a divorce. The Olty lien allows a party acquiring the interest of a co-owner to place a lien on the entire property. Redemption. The right of a defaulted property owner to recover property by curing the default. Redemption period. A period of time established by state law during which property owners have the right to redeem their real estate from a foreclosure or tax sale by paying the sales price, interest, and costs. Many states do not have a mortgage redemption law. Release of lien. A lien on a property that is now free of a mortgage, from a mortgage. Okay, so when the lien was taken over, then it was free. Woo! Okay, special assessment. A tax or levy customarily imposed against only those specific parcels of real estate that will benefit from a proposed public improvement, like a street or a sewer. Specific lien. A lien affecting or attaching only to a certain identified parcel of land or piece of property. Statutory lien. The lien imposed on property statute, a tax lien, for example, in contrast to an equitable lien, which arises out of common law. Okay, so do you see my little yellow face there? I'm going to adjust the screen. I'm gonna see if I can do this. I don't think it's gonna let me. All right, hold on 1 second. Okay, so just bear with me for 1 second while I darken me up. Okay. All right, there we go. That's not much better, is it? Hold on a minute. Well, you can barely see me. I may just turn myself off. What do you think about that? All right, statutory right of redemption is the right of a defaulted property owner to recover the property after its sale by paying appropriate fees and charges. Subordination, relegation to a lesser position, usually in respect to a right or security. So if you want to refinance that first part of the mortgage, they will only do it if there's a subordination agreement in place with that second mortgage. Subordination agreement, a written agreement between holders of liens on a property that changes the priority of the mortgage, judgment, and any other liens under certain circumstances. Again, generally in our world, a refinance. Tax basis, the point from which gains and losses are figured for tax purposes. Tax credit, any amount by which tax owed is reduced directly. Tax levy, the formal action taken to impose tax, usually by vote of a taxing district's governing body. Tax lien, a charge against property created by operation of law. Tax lien and assessments take priority over all other liens. So when we talk about the priority, the taxes in the municipal will be first. Then comes the mortgage. Tax sale, a court-ordered sale of real property to raise money to cover delinquent taxes. Vendor's lien, a lien that belongs to a vendor for the unpaid purchase price of land, where the vendor has not taken any other lien or security beyond the personal obligation of the purchaser. Voluntary lien, a lien placed on the property with the knowledge and consent of the property owner. Writ of attachment, a document ordered by the court to have a sheriff enter a leased property to give possession back to the owner. Liens, so liens are the charges or claims against a property to enforce payment of money. And all liens are encumbrances, but not all encumbrances are liens. So what I'd like you to do in the chat is just type to me an example of an encumbrance that is not a lien. Okay? One could be an encroachment, right? So liens, charges or claims against a property to enforce a payment of money. Okay, so same thing. All right, so different types of lien. Voluntary, right? So that would be a mortgage. Involuntary, that could be another bill that was out there, or a mechanic's lien. Statutory, so that would be something that was available because of the statute, right? So by law. Equitable, general and specific. Okay, so again, the effect of a lien on a title is that the lien needs to be released or for it to be cleared, right, at closing. And again, priority of liens has to do with subordination agreements, right? So that the mortgage wants to be top, okay, after taxes and municipal. So if they do a refinance, because of the date, it would be down here, but they want subordination agreements in place so that they are on top. All right, so ad valorem taxes are general taxes, right? Would you like to type into your chat some examples of ad valorem taxes for me? All right, and what are some special assessments, right? And those could be what we call improvements. One could be equalization, right? So they talked about that, equalizing it for tax, like for state purposes. Tax rates, right? Every year we get a new tax rate for each municipality. The tax bills, which are what we pay, right? And then the statutory right of redemption, right? Which is you have a chance to redeem your paying your taxes before they would do a tax title or take over, right? So other liens in real property, your mortgage lien, right? That's the one that we most of the time think of. Mechanics lien, which would be, and it's not just mechanics, right? It's different services or whatever that have been done to the property and they had not been paid. So they put a lien on there. Okay, now a judgment could be that a court judges it, right? Puts a lien on it. Could be lease pending, right? A lease pending example would be when, say there was a broach a breach in a sale or something, and they were going on and they were going to sell it to someone else, and they breached their agreement with you, you could file a lease pending against that property because they had breached your agreement, right? So a lot of times if sellers are trying to get out of selling to a certain person after they've been in contract and they want to move on to someone else, what that buyer will often do is say that they're going to do a lease pending. A writ of attachment. Okay, so we talked about the writ of attachment is the language, right? And estate and inheritance tax liens. Okay, so it comes when someone passes away. Other liens would be liens for municipal utilities, again, if you have not paid them, a bill bond lien, corporate franchise tax liens, and IRS tax liens. Okay, so now let's jump over. We see red, so we know that means we're jumping into the state, okay? So in Massachusetts real estate taxes, each town and city in the state is responsible for raising revenue through property tax. The tax year begins January 1st, although for budgeting and appropriation purposes, a community may use the fiscal year from July 1st to the following June 30th. The purpose of real estate taxes is to fund a community's budget. Once the spending plan has been decided, the community must determine how to most fairly distribute the cost of programs and services among property owners. All property within a community is assessed at the same time. All property is assessed at 100% of its full cash value or fair market value. Then the amount of the community's budget that would be raised from real estate taxes is divided by the total number of all assessed values. Okay, so we take the total bill and we divide it by who's there, right? The result is the amount of the budget each dollar's worth of the property will bear, generally quoted as X dollars per thousand of assessed value. So where are we going with this? Mill, right? Okay, annual real estate tax bills are prepared by local municipalities, right? We all have to figure out what the bill is. That's why we have all of our different taxes, right? Okay, so most cities and towns mail out bills in quarterly installments. Bills for improvements made by the municipality are due annually on November, okay? So you've all heard of Proposition 2.5. What is it? It's the title given to an initiative petition adopted by the voters of the Commonwealth in Massachusetts in 1980, also known as the year I graduated high school. The primary feature of Proposition 2.5 relates to the total amount of property taxes a city or town can raise each year, right? So you can only go up 2.5% increase of the full cash value of all taxable property in the city or town and cannot increase more than 2.5% year over year, okay? So if you wanted to, right, because the cap may adversely affect tax-dependent bodies such as schools and emergency services, individual communities may vote to override it. So a lot of time there'll be a town meeting to override Proposition 2.5. All right, so in Massachusetts law provides that taxes on real estate become a lien on the property as of January 1st in the year of the assessment. Okay, so would that be a voluntary lien? Type it in. The lien for unpaid real estate taxes consists of real estate taxes owed as well as fees and charges. A lien for unpaid real estate taxes is superior to other liens, including prior mortgages, because the tax lien attaches to the property as a whole. So, Mass General Law 60 and 65 says real estate taxes that remain unpaid 2 years after they are due may be collected by tax sale of the property. All right, so generally speaking, your taxes are significantly lower in value than would be your home, right? Your home value. Wait a minute, I think I might have missed a slide there. Hold on one sec. Because the owner has 6 months from the date of the tax sale to redeem the property, called the statutory right of redemption, the purchaser of a tax deed cannot be assured of taking title, right? There's that 6-month period. So if no redemption has been made within 1 year of the date of the tax sale, the new owner can bring an action in the land court to register the title and confirm ownership. Land court registration and the Torrens system are described in Chapter 9, right? So the Torrens system, that's the system created for land registered. All right, a municipal lien. A municipal lien certificate, also called an MLC, right, for us when you go to the town before a closing, indicates unpaid real estate taxes, water charges, betterments, assessments, and other unpaid or current financial obligations levied by the town or city against the land. Mass General Law 60, subsection 23, requires the tax collector's office to furnish, upon a written request, a completed municipal lien certificate to the applicant within 10 days, excluding Saturdays, Sundays, and holidays. Okay, so what they're looking for there is to see what will be credited or debited, right, on the settlement statement, because those liens would get paid. So the MLC will tell us what's owed. Okay, they are recorded along with the deed and the mortgage. Municipal liens on a property may be ascertained by checking the records at the Registry of Deeds for the county in which the land is located, or by securing municipal lien certificate from local tax collector. And that is generally what we see, right? The Massachusetts Mechanics Lien Statute extends mechanics lien protection to a broader range of persons providing labor and materials. So I alluded to this earlier. It also gives rights to persons and parties involved in the alteration, erection, repair, or removal of a building, structure, or other improvement to the real property, as well as parties furnishing material for rental equipment, appliances, or equipment, as well as parties providing construction management and general contractor services. Okay, so for services as well. Under this revised statute, a mechanics lien can attach to a leasehold interest of a contracting party, whereas the prior version of the state required the contracting party to be the owner of land to which the lien was attached. In addition, it is no longer necessary that the lien relate to work on a building or structure, giving lien rights to site work contractors such as landscapers, parking lot surfacers, and utility contractors. So you see that mechanics lien is called the mechanics lien, but it's not only just a mechanics lien. All right, so special assessment and betterments. Mass General Law, Chapter 80. A special assessment or betterment is in a special property tax that is permitted when real property within a limited and determinable area receives a special advantage or benefit. A special assessment or benefit is a lien on the benefited property. Common special assessments are water, sewer, sidewalks, and so on. So Title V betterments. Okay, so Title V betterment would be if there was a Title V that needed to be done, okay, and for whatever reason, either the Title V person got paid at closing, or if for some reason they had to put a betterment fee that was assessed for it. Okay, so there's a couple different ways that could happen. All right, condominium certificates and condominium super liens. Okay, so we talked about this in the condo chapter, where the super lien means that this goes up in priority after the municipal taxes, before the mortgage, for 6 months worth of HOA fees that are due. Okay, and why is that? Type in why you think that would be, okay? The reason why that would be is because these condo associations need everybody's fees in order to sustain the common areas, right? Another tax credit and deduction could be a tenant deduction, a renewable energy source credit, okay? And again, we are a big state for using alternative energy. Lead paint removal credit. So if there was lead paint that needed to be removed. One of the things is we have one of the older housing stocks. Okay, so next we have real estate financing. So this is 12 and 14. So 12 in some of your books and 14 in the others, okay? So what is financing? Many homes in the United States are bought with borrowed money, right? And a huge lending industry has been built to service the financial requirements of home buyers. It is important for real estate professionals to be knowledgeable about real estate financing programs and products in order to provide quality service, especially when representing a buyer, okay? So generally speaking, I call it the triangle. So your triangle is, we have the real estate services that we provide, a mortgage or a lender would have the services that they provide, and then the attorney would have the legal services that they provide. And that's kind of our professional triangle for our consumers. So our objectives in this unit, okay, is to describe the various aspects of housing affordability. Now this includes mortgage terms, ability to pay, and investment and tax considerations. And we're going to describe the terms, conditions, and use of a promissory note. And we're going to explain the elements and use the security instruments, the elements and use of security instruments, and describe the mortgage deed of trusts and the roles, rights, and obligations of the parties involved. We're going to describe various types of real estate financing, explain the distinction between a judicial foreclosure and a non-judicial foreclosure and the process involved in each, and describe the various consumer protections related to homeownership. Okay, so I'm going to, these are your vocab words. Again, you can stop this if this is in replay for you, and you can get out your phone and you can get your glossary and you can answer these. Or you can come along with me when we get to the words. I'm going to give you the definitions. I feel that it's important to hear these definitions a few times because why? Right? 7 times. It takes 7 times before something starts to register for you. And we want to fill your brain with all the knowledge that it doesn't even know it has. Okay? Acceleration clause. The clause in a mortgage or deed of trust that can be enforced to make the entire debt due immediately if the borrower defaults on the installment payment or other obligation, right? So they accelerate the mortgage. Adjustable rate mortgage, or ARM. A loan characterized by a fluctuating interest rate, usually one tied to a bank or savings and loan association cost of funds index. Alienation clause. A clause in a mortgage or deed of trust stating that the balance of the secured debt becomes immediately due and payable at the lender's option if the property is sold by the borrower. In effect, this clause prevents the borrower from assigning the debt without the lender's approval, and also selling your house without paying off your mortgage. Amortized loan is a loan in which the principal, as well as interest, is payable in monthly or in other periodic installments over the term of the loan. Annual percentage rate, or APR, the relationship of the total finance charges associated with the loan. This must be disclosed to borrowers by lenders under the Truth in Lending Act. Assumption of mortgage. Acquiring title to property on which there is an existing mortgage and agreeing to be personally liable for the terms and conditions of the mortgage, including payments. So a lot of times you'll hear about assumable mortgages. And by the way, this in the newer book, they talk about assumable mortgages a couple times. So it might be something to pay attention to when you're doing your reading, okay? Automatic underwriting. Computer systems that permit lenders to expedite the loan approval process and reduce lending costs. A lot of times, automatic underwriting might be done for refinances. Most of the time for us in our area, okay, they are not done for mortgages. Okay, first time out for home sales. Balloon payment. A final payment of a mortgage loan that is considerably larger than the required periodic payments because the loan amount was not fully amortized. Beneficiary. The person for whom a trust operates or in whose behalf the income from the trust estate is drawn. And then it's also a lender in a deed of trust loan transaction. Okay, so that would be the beneficiary. Two different definitions there, right? Co-insurance clause. A clause in insurance policies covering real property that requires the policyholder to maintain fire insurance coverage generally equal to at least 80% of the property's actual replacement costs. Collateral. Collateral, something to have value, something having value that is given to secure repayment of a debt. Okay? Comprehensive Loss Underwriting Exchange, or CLU, is a database of consumer claims history that allows insurance companies to access prior claims information in the underwriting and rating process. Okay, so taking the person's history or the property history to find out what's been going on. Computerized loan origination, or CLO. That is an electronic network for handling loan applications through remote and computer terminals linked to various lenders' computers. Debt to income. Information about an applicant's gross income and total debt that lenders generally look at as a percentage to determine qualifications for a loan. Deed in lieu of foreclosure. A deed given by mortgagor to the mortgagee when the mortgagor is in default under the terms of the mortgage. If accepted by the mortgagee, this is a way for the mortgagor to avoid foreclosure. Okay, so actually it's still a foreclosure, but you don't have to go through all of the official foreclosure proceedings. And we will talk about that a little bit more on the state portion, okay? Deed of reconveyance. A document that a trustee uses to transfer the title back to the trustor or the borrower when the note is repaid. Defeasance clause. A clause used in leases and mortgages that cancels a specific right upon the occurrence of a certain condition. Okay, so cancels a right upon the occurrence of a condition, such as cancellation of a mortgage upon the repayment of the mortgage loan. Deficiency judgment. A personal judgment levied against the borrower when a foreclosure sale does not produce sufficient funds to pay the mortgage debt in full. In some states, a deficiency judgment cannot be sought when the mortgage debt was used to purchase and is secured by the borrower's principal residence. Okay? Discount point. A unit of measurement used for various loan charges. 1 point equals 1% of the amount of the loan. Okay, so this is always a trick on the test. So they will give you the mortgage amount. I mean, they'll give you the sale price. They won't tell you what the mortgage amount is, but they will give you enough information so that you can ascertain what the mortgage amount. This discount point goes on the mortgage amount. Okay, remember that. Discount rate, the interest rate set by the Federal Reserve that member banks are charged when they borrow money from the Fed. Through the Fed. Due on sale clause. A provision of the mortgage stating that the entire balance of the note is immediately due and payable if the mortgagor transfers or sells the property. Equity. The interest or value that an owner has in property over and above any indebtedness. Estoppel certificate. A document in which a borrower certifies the amount owed on a mortgage loan and the rate of interest. Okay, so that would be found in your estoppel certificate. Financial Institutions Reform, Recovery, and Enforcement Act, or FIREA. This act restructured the Savings and Loan Association regulatory systems enacted in response to the saving and loan crisis of the 1980s. Okay? So again, we're always like either in a reform, tightening, or loosening, right? Where do you think we are now? Why don't you tell me where you think we are now? Are we tightening or are we loosening? Financing. The business of providing the funds that makes real estate transactions possible. First mortgage. A mortgage that has priority over all other mortgages. Foreclosure is a legal procedure whereby property used as security for a debt is sold to satisfy the debt in the event of default in payment of the mortgage document. Okay, so it's the legal procedure whereby that property is taken over. The foreclosure procedure brings the rights of the parties to a conclusion and passes the title in the mortgage property to either the holder of the mortgage, which would be the bank, right? Or a third party who may purchase the realty at the foreclosure sale. Okay, so they have a foreclosure auction and either it goes back to the bank or somebody else can buy it. Okay, depending on the priority of the foreclosed mortgage, the property may be sold free of all other it may be sold free of all other encumbrances incurred prior to the sale. Sometimes not, right? That's what it doesn't say. Fully amortized loan. A loan consisting of equal regular payments satisfying the total payment of the principal and interest of the due date. Okay, so I'm fully done. Graduated payment mortgage. A loan in which the monthly principal and interest payments increase by a certain percentage each year for a certain number of years and then level off for the remaining loan term. So why would somebody have one of these? Say it was a building, right? So say it was a construction loan and you start off by paying just the interest and then you pay on the stuff that's on the value of the property as the improvements are being made. Growing equity mortgage. A loan in which the monthly payments increase annually with the increased amount being used to directly reduce the principal balance outstanding and thus shorten the overall term of the loan. Okay, so growing equity mortgage. So the more equity you have, the lower the loan goes. Home Mortgage Disclosure Act, a federal law implemented at its creation by Regulation C of the Federal Reserve that requires lenders to annually disclose the number of loan applications and loans made in certain areas to avoid the practice of redlining, right? And we've talked about redlining a couple times. On July 21st, 2011, the rulemaking authority of the law was transferred to the Consumer Financial Protection Bureau, okay, or CFPB. Homeowners insurance. Insurance that covers a residential real estate owner against financial loss from fire, theft, property liability, and other common risks. Hypothecation. To pledge property as security for an obligation or loan without giving up possession of it. Index. An objective economic indicator to which the interest rate for an adjustable rate mortgage is tied. Interest. A charge made by a lender for the use of the money. Interest-only loan. A loan that requires only the payment of interest for a stated period of time with the principal due at the end of the term. Again, a lot of commercial loans are set up this way, or investment loans. Liability coverage. Feature of homeowners insurance that covers injuries or losses sustained within the home. Okay, so liability, you'll hear about liability. Lien theory. Principle in which the mortgagor retains both legal and equitable title to a property that serves as security for a debt. The mortgagee has a lien on the property, but the mortgage is nothing more than collateral for the loan. Okay, so this is a lien theory state that you will hear about, okay, or a legal title state. All right. Loan origination fee. A fee charged to a borrower by the lender for making a mortgage loan. The fee is usually computed as a percentage of the loan amount. Loan to value ratio. The relationship between the amount of the mortgage loan and the value of the real estate being pledged as collateral. Margin. The premium added to the index rate representing the lender's cost of doing business. Mortgage. A conditional transfer or pledge of real estate as security for the payment of a debt. Also, the document creating a mortgage lien. Okay, so it's called a mortgage. What's your mortgage, right? That's what we always hear. What's your mortgage on the property? What's their mortgage? Mortgage banker. A mortgage loan company that originates, services, and sells loans to investors. Mortgagee. A lender in a mortgage loan transaction. Mortgagor. A borrower in a mortgage loan transaction. Right, so you gotta get straight who's who. All right, negative amortization is a process by which the amount of the loan increases. The mortgagor sets a payment cap or maximum amount of payment made and the full payment amount is added to the remaining mortgage balance. Negotiable instrument is a written promise or order to pay a specific sum of money that may be transferred by endorsement or delivery. The transferee then has the original payee's right to payment. Non-conforming loan. A loan that exceeds the Federal Housing Finance Agency, or FHFA, loan limits, also called a jumbo loan. Novation. Substituting a new obligation for an old one or substituting new parties to an existing obligation. So some of the other definitions that you've had talk about assumption and substitution, right? So novation would be substituting a new obligation for an old one or substituting new parties to an existing obligation. P and I is principal and interest. All right, participation mortgage. A mortgage loan wherein the lender has a partial equity interest in the property or receives a portion of the income from the property. Payment cap. The limit on the amount of money payment can be increased on an adjustable rate mortgage when the interest rate is adjusted. PITI. The basic costs of owning a home, mortgage principal and interest, real estate taxes, and hazard insurance. So a lot of times when you are trying to figure out what they can afford, it has to do with PITI, right? So a lot of times what we'll know is that mortgage piece, but we won't know the rest, okay? But the mortgage person will, and that's why we keep them in the loop. Point is the term used for a percentage of the loan principal amount Okay, a term used for the percentage of the principal loan amount charged by the lender. Each point is equal to 1% of the loan amount. Okay, so as I said before, it's the mortgage amount. Okay, it is not the sale price. That is always a question. They always try to catch you guys on that. But my students are not going to be fooled by that. Hold on one second. I'm just going to respond to something. Okay, sorry about that. Prepayment penalty. A charge imposed on a borrower who pays off the loan principal early. This penalty compensates the lender for interest and other charges that would otherwise be lost. Promissory note. A financing instrument that states the terms of the underlying obligation is signed by its maker and is negotiable, okay, or transferable to a third party. A rate cap. The limit on the amount of interest rate can be increased at each adjustment period in an adjustable rate loan. The cap may also set the maximum interest rate that can be charged during the life of a loan. Release deed. A document, also known as the deed of reconveyance, that transfers all rights given a trustee under a deed of trust loan back to the grantor after the loan has been fully repaid. Okay, so you get a release deed. Reverse mortgage. A loan by which a homeowner receives a lump sum, monthly payments, or a line of credit based on the homeowner's equity in the property secured by the mortgage. The loan must be repaid at a prearranged date upon the death of the owner or upon the sale of the property. Okay, so again, this is this part of when we're going to talk about foreclosures next. This is one of the big new errors in foreclosures are these reverse mortgages, because the house may not be worth what the equity that the seniors pulled out, or that it doesn't get transferred fast enough, or a whole bunch of little issues that have happened. So kind of interesting. Satisfaction of mortgage. A document acknowledging the payment of a mortgage debt. Shared appreciation mortgage, or SAM. A mortgage loan in which the lender, in exchange for the loan with favorable interest rate, participates in the profits, if any, the borrower receives when the property is eventually sold. Okay, so kind of interesting. I've never seen one before, so I can't give you any stories about that. Now, short sales, on the other hand, I've seen a ton of. Okay, so short sales are a sale of a property in which the sale price is less than the remaining indebtedness. Okay, so this would be for basically when the bank will accept short money to satisfy a loan because the homeowners, for whatever reason, are in distress or hardship and can't pay it. Straight loan. A loan in which only interest is paid during the term of the loan, with the entire principal amount due with a final interest payment. Again, would be debt for somebody who's doing a flip or something, and when they get paid there, when they sell it, they would pay off the end, right? Subject to a clause in a contract specifying exceptions or contingencies of a purchase. Okay, so a lot of times the purchase and sale agreement will be subject to a mortgage, being able to get a mortgage. Title theory. Principle in which a mortgagor conveys legal title to the mortgagee or some other designated individual and retains equitable title in the right of possession. In effect, because the lender holds legal title, the lender has the right to immediate possession of the real estate and rents from the mortgaged property if the mortgagor defaults. So you've got title theory states and lien theory states, right? So we talked about lien theory before, and this is the opposite. This would be where the bank actually holds title, not the homeowners. Trust deed. An instrument used to create a mortgage lien by which the borrower conveys title to a trustee who holds it as a security for the benefit of the note holder, the lender, also called a deed of trust. So I'm going to read that one again. An instrument used to create a mortgage lien by which the borrower conveys title to a trustee who holds it as security for the benefit of the note holder, the lender, also called the deed of trust. Trustor. A borrower in a deed of trust loan transaction, one who places the property in a trust, also called a grantor or a settlor. Usury. Charging interest at a higher rate than the maximum rate established by state law. you think that that's legal? Variable rate mortgage. A mortgage loan in which the interest rate varies depending on market conditions. Okay, so that rate could vary, right? So those are your words. And again, I hope that you have taken some time to put your words to your voice onto your audio so that you can listen to yourself and not just me. Because let's face it, you guys get sick of listening to me. All right, so let's talk about housing affordability. And I think that housing affordability is becoming, a lot more context on the exams. Okay, so the first thing that happens is, what are the mortgage terms, right? So what are the terms that they're gonna loan that money? Now, the ownership interests and the ability to pay depend on PITI. I think I said that when we were doing definitions, right? So we kind of in our brains figure out what the mortgage, like what the finance part will be, but we don't know. So we know the principal. We can kind of figure out a little bit the interest, but we don't know the taxes and we don't know the insurance write-off, right? So our estimates are normally a little low. And what the banks are often looking for is a debt to equity, a debt to income ratio. All right, so whatever the number is that they use, it depends on the person's income, how much debt they can assume. All right, so some investment considerations are the tax deductions and benefits. Okay, so why would somebody want to invest their money, right? So a promissory note. What is a promissory note? It is the negotiable instrument, okay, that's used. It's also what? The mortgage note, right? So it includes the interest. Now it says here usury. Now usury would be the more than the maximum allowed, right? The loan origination fee, discount points, and prepayment penalties. So what they're trying to do is lay out anything that could possibly happen in this promissory note, okay? Now security instruments. Now we talked about mortgage loans, so the loan is one of them, and hypothecation is what? Okay, do you remember your word? I want you to type it into your chat below, okay? And then the lien theory. What is the lien theory? The lien theory is that the mortgage is taken out, but the property actually belongs to the owner, right? The person who's mortgaging, not the mortgage company. So in real estate financing, here are some of the things that get identified. Okay, the first is the duties of the borrower, right? What is the biggest duty of the borrower? To pay the mortgage, right? What would be another one? To keep the house, right, in good condition for the bank. All right, so what are the provisions of default? So it's interesting because people say, well, when is that person late on their mortgage? The person is late on their mortgage the day after that due date, right? So if it's due on the 1st, then on the 2nd, it's late. Okay, I say that because on most of the mortgage payments, there's a grace period that they don't give you an extra fee. But theoretically, when they start counting the days that you are in default, they start the day that it's late, okay? So assignment of the mortgage. So that would be that it could be assigned to another person, perhaps, or, and what was that word that we used for that? Was it novation, right? Perhaps, right? And again, assignment of the mortgage, if in the event of default, would be what? Foreclosure, right? So release of the mortgage lien or deed of trust, okay? The clause that we talked about, the satisfaction kind of clause would be the defeasance clause. Okay, that would be the satisfaction of that mortgage. All right, so tax and insurance reserves. So a lot of times a bank will hold reserves. They do the taxes for a year, so that you pay your taxes for a year when you are signing up. And then again, flood insurance is another big one, and a lot of times they'll put some in reserves for that if you're in a flood zone. Okay. Now, they say buying subject to or assuming the seller's mortgage or deed of trust. Okay, so alienation clause. Remember, alienation clause, would mean that you're voluntarily assigning it, right? Involuntary alienation. Recording a mortgage or deed of trust, and then priority of the mortgage or deed of trust. And we talked about the priorities. We've mentioned a few different things. So taxes and municipal goes first. Then generally speaking, the mortgage would go second, the primary mortgage. Now, the condo super lien could go higher. And what else did we say could go higher at some instances? I can't remember. We'll have to, when we come to it, we'll have to remember. You guys can help me. Tell me. All right, different kinds of loans. The straight would be an interest only. So they figure out the full interest on the property. They divide it by the number of months that you're going to be paying, and you come up with your loan. This is not how it normally works. It normally works by an amortized loan, okay? And that amortized loan means that you are paying interest on the amount of the principal. So each month there is a difference in how much principal has been paid and how much interest is due on that. So what you will see when you look at the charts on this is kind of like a gap that shows interest, mostly interest, some principal, and over time the interest shrinks and the principal rises. Okay, so it looks kind of like a triangle-y type thing, right? All right, adjustable rate mortgage. So that would be that you have a certain lower amount normally for the first few years. Again, a specified time. I'm using 3 years because that was what we normally see, right? And then at the end of that time, you would have a new rate of a mortgage and you would kind of refinance. And this was one of the big challenges of our recession that we just are coming out of. It was because these adjustable rate mortgages, after the interest rates were so high, the homes were not worth what they were worth before. The value had decreased and they couldn't get mortgages, So those are always a little bit riskier than just a straight or an amortized loan. Growing equity mortgage. Again, so as the property gets more valuable, your mortgage payments go higher. A balloon payment, just like the name of it. At the end, you would have a bigger lump sum. Again, these are generally used for investment purposes, or when you know you're going to be selling, and you don't want to be putting all your money down. You'll get it back when you settle up when you sell, right? And then a reverse mortgage, that would be for the senior citizens. They're taking equity out of their property once they get to it, right? And they have sometimes an income to live on, so a good option, but just to proceed with caution. So I've said that a few times. So I hope what you're hearing me say is let the professionals do their job, okay? And we do our job. All right. Now, foreclosure. We talked about foreclosure. That would be when the bank takes back their house because of non-payment, right? And they foreclose on the loan. Now, it could be judicial, where there's a court sale, in which case it goes to the court. The court then would take it and they would order foreclosure kind of thing. Now, we are a non-judicial state, okay? So ours is done by an auction, okay? Again, this says strict here. So the banks are, when it's funny because when people hear about different kinds of this house, they haven't paid their mortgage in 3 years and they're still there, they haven't started foreclosure, that is an exception to the rule, okay? And there's a whole process. There's a process by which notification has to happen. There has to be times there's times, and we'll talk about this when we talk about Massachusetts, where you can try what we call loss mitigation or trying to come up with ways to keep the house, right? But they have definite rules once they start the foreclosure process. Now, one thing that's available sometimes is called the deed of in lieu of foreclosure, in which case what they do is they say that that they will take the keys to the house and basically you move out and the bank takes it over. It is still considered a foreclosure, okay? But it's without the embarrassment and without the hassle, basically. Redemption. So that would be the period that in some states, there's a redemption period where you have the right to try and redeem yourself, basically. All right, deed to purchaser at sale, right? So that would be at the foreclosure sale or whatever. And generally, again, there's different times that you can take it over. Remember when we talked about the tax taking, that you've got the days that you could have that right of redemption. Now, deficiency judgment. If a property in a short sale where the bank said, you know what, we know we're not going to get all the money back from you for the amount you took out, plus the fees and fines and all that kind of stuff. Here's the number. Here's what we can sell that house for. We'll accept that as a short sale, right? So they approve the short sale, but there's that piece of money, could be $20,000, could be whatever, that there's a deficiency judgment on it. And it's always unclear what the bank is going to require, So we don't want to, as real estate professionals, say, like, oh, they'll give you deficiency judgment forgiveness or debt forgiveness on that. Sometimes they do, sometimes they don't. Sometimes you pay taxes on it, sometimes you don't. So it really depends on what the arrangement and agreement is. Okay. Now, back when we had our recession, there was a whole bunch of abuse going on. As I said to you, like a lot of times restrictions are loose and then they come back together. So one of the things for the consumer protection was the Dodd-Frank Act. And with the Dodd-Frank Act, what happened then was that, the people who were giving you the mortgages had to start disclosing what it was that they were going to be charging you for fees and whatnot. Okay. So this actually gets to, and again, we'll talk about this when we get to the next pieces, the different steps that we have now for consumer protection. All right. Homeowners insurance, making sure that you have, insurance that's reasonable. Again, coverage and claims for all the different kinds of, catastrophic type things that we've had. Comprehensive loss underwriting exchange. Again, that would be where the computer kind of comes up with an amount and an underwriting type thing. It's a computer generated system for you. And then again, federal flood insurance program. So, which is also called FFIP, right? And we live in an area where I am videoing from, where there's a lot of flood properties in the flood zones. So we're all pretty familiar with a flood. Okay, so we're red, right? So we know what that means, right? So red slides mean what? State, okay? So real estate financing and principles and practice for the state. Okay, so the mortgage law. So we are a title theory state. Okay, that means that the mortgage splits title in the property, and the mortgagee takes legal title, while equitable title is retained by the mortgagor. The granting of the property to the mortgagee by the mortgagor is done with an instrument that is similar to a warranty deed, except that the document contains provisions permitting that the mortgagor get to take the property back if they fulfill certain conditions. Generally, these conditions are, okay, so let's walk through this one more time. We are a title theory state in Massachusetts. That means that the mortgage, splits title of the property. The mortgagee takes legal title, which is the bank, right, generally, while the equitable title is retained by the mortgagor, right, the person who's moving into that house, the buyer. The granting of the property to the mortgagee by the mortgagor is done by an instrument similar to a warranty deed, except that the document contains provisions permitting the mortgagor to get the property back in full under certain conditions. Okay? Generally, these conditions are pays the sum of the money with interest as provided in a separate promissory note. So they get to be both the legal title and equitable title when these things happen. Keeps the property insured for the benefit of the mortgagee. Promptly pays taxes assessed against the property. Keeps the property in good repair and does not allow the property to be waste. Again, that's what we talked about before. They have to keep it up, right? Does not remove any buildings or improvement from the property. Okay, so the property stays as it is. So the mortgage discharge, which is under Mass General Laws 183, subsection 54 and 55, and also Chapter 63, Acts of 2006. Within 45 days of receiving full payoff funds, the mortgagee must record at the registry, right, an effective discharge, which includes recording or providing any necessary documentation, including assignments to make the discharge effective. Okay, documentary proof is needed to establish the authority of the servicer or note holder to discharge this mortgage. So some financing techniques. The Massachusetts banks are permitted to make purchase, participate in, or service a wide variety of statutorily approved real estate mortgage loans, including certain loans in excess of 95% of the value, open-ended mortgages, and reverse mortgage loans. In Massachusetts, several agencies provide financing and loan programs for homeowners and renters. So one is Mass Housing, one is the Massachusetts Housing Partnership Fund, and one is the Massachusetts Department of Housing and Community Development. Okay, different kinds of financing technique. All right, so again, some of the things that we are trying to avoid are predatory lending. All right, so let's cover some of the predatory lending. Using false appraisals to sell properties for much more than they are worth, encouraging borrowers to lie about their income, expenses, or cash available for down payments to get a loan, knowingly lending more money than a borrower can afford to repay, charging high interest rates to borrowers based not on their credit history but on their race or national origin, charging fees for unnecessary or non-existent product and services, pressuring borrowers to accept higher risk loans such as balloon loans, interest-only loans, and steep prepayment loans. Okay, so you're seeing where some of this predatory lending comes in. And again, this was part of that whole crash thing. convincing homeowners to refinance again and again when there is no benefit to the borrower, thereby stripping homeowners' equity from their homes. Using high-pressure sales tactics to sell home improvements and then financing them at high interest rates. Okay, so those are all like examples of predatory lending. Okay, so licensing of MAS, the mortgage companies and the loan originators. Okay, so let's talk about that. The Division of Banks, licensed mortgage lenders and brokers, and mortgage loan originators pursuant to Mass General Law 255E and its implementing regulations found at 209 CMR 42 and sequence, and Massachusetts General Law Chapter 255F and its implementing regulations found in 209 CMR 41 and sequence respectively. Okay, so this is where those are all identified. Here's what they spelled out. Mortgage broker license. Okay, what that is, a mortgage broker license branch. A mortgage lender license and a mortgage lender license branch. A mortgage loan originator license, and then all the professional requirements of each. So a lot of times you will hear when people are talking about, wanting to be your mortgage professional, they'll say, and I'm a bank, I'm not just a whatever, right? So you can figure that out and work with them accordingly. All right. Amortized loans. Again, this is what most of the loans are that we see. In Massachusetts, amortized loans are called direct reduction loans. The payments on a direct reduction loan are the same amount each month. Each payment pays some of the interest on the loan and some of the principal amount borrowed. Initially, most of the payment is credited to the interest, with very little credited to the principal. Eventually, payment increases toward the principal and decreases toward the interest. So what we find is on a 30-year mortgage, if it goes by the amortized schedule, at about year 7, it starts to tip the scale and start going to paying more on the balance and less on the loan, less on the mortgage. So what happens when you are paying, like when you are buying a house and planning on spending it in 5 years? I mean, selling it again in 5 years. There's a good chance that you're like the amount that you mortgaged, right, that you bought the house for, you still owe. Okay, that's a big surprise for a lot of people. Default. Default occurs when any condition of the mortgage is not satisfied by the mortgagor. A default will activate the acceleration clause in the mortgage and cause the entire debt to be due immediately. In most Massachusetts mortgages, the mortgagee will have included a power of sale clause, giving it the right to immediately possess the property, to advertise the property as having been foreclosed, and after a stated period, to sell the property and apply the proceeds to the unpaid balance of the loan. Okay, so Massachusetts has undergone many changes in its foreclosure laws. Okay, so what examples can you all think about? And I'd love you to just write in the messages and send us a message. What are the examples of a default? Okay. Now, the right to cure a mortgage default. All right, in November 2007, again, so this is after big houses, so 2007, right, was as we were, so what, 4, 5, 6, and 7, right? That's when we kind of had our rough years, right? So in 2007, the governor signed into an act protecting and preserving homeownership, which provided homeowners who were facing foreclosure a 90-day right to cure default after written notice and given by the mortgagee to the mortgagor. The 90-day right to cure applied once in a 5-year period, regardless of the mortgage holder. Okay, so once you start going in default, they give you a 90-day right to cure. Okay, now this 90-day right to cure in August of 2010 was extended to 150-day right to cure. Okay, or 90-day right to cure notice if applicable. Okay, lenders cannot accelerate a foreclosure on the property during those 150 days. So before, when I was saying that there were strict guidelines, so the day that you're in default, right, the day your mortgage is late, okay, 150 days from there, okay, is granted to them once in every 3-year period, regardless of the mortgage holder. So again, if your loan has been serviced and you refinanced it with someone else, you still have that 3-year period, okay? If homeowner remains in default, the power of sale clause is activated, which means what? Foreclosure, right? So the right to cure the mortgage, okay, in accordance to Mass General Law 244, subsection 35A, right, a mortgage may send a 90-day right to cure provided the mortgagee can demonstrate that it is negotiated in good faith with the borrower. The mortgagee certifies that it has negotiated to reach an alternative to foreclosure in good faith of the borrower. Okay, so they have to give them the opportunity to try to mitigate, right? At least one meeting has taken place between the mortgagee and the borrower. So these are all the different steps that have to be shown before the foreclosure. The mortgage provides loss mitigation information to the borrower before the meeting, which means how can you get out from underneath this, right? And after the meeting, the creditor is able to demonstrate that they were not able to reach a resolution other than foreclosure. Okay, so there's loan modifications that they talked about, and there was loan refinancing. So there's two different programs that come up, right? Some states use judicial foreclosure process, which requires the lender to file a foreclosure action in the court system and receive an order from a judge before the property goes to foreclosure sale. Now, in Massachusetts, we are a non-judicial foreclosure process, which the lender only has to put the borrower on notice, right? That 150 with 90-day right to cure the default. In addition, Massachusetts also requires an order of notice be obtained to be determined if the property owner is entitled to relief, right? So they do not foreclose on Servicemen's Civil Right Act for the person who is active right now in the service, right? Filing a petition to foreclose in land court, okay? So that, by the way, is one of the things that we look for to see how they're making out, like when we go to for a home sale, and we think that there might be some hardship. One thing that we check to see is that has that service members act been filed at the Registry of Deeds. Okay. Other provisions in the Act protecting and preserving homeownership, which they called HOPE, right? All foreclosure notices are now required to be filed with the Division of Banks, which allows the division to better track foreclosures and the lenders and brokers whose loans lead to foreclosure. The division will also retain contact information for those responsible for maintaining vacant foreclosed properties. Okay, so that's another big reason why they don't sometimes foreclose on people right away. It's because then the properties are abandoned, and then the bank owns them, and now they're getting in worse condition because nobody is not committing waste, right? Licensing of all mortgage loan originators is required, not just companies that employ loan originators. Counseling is mandatory for first-time home buyers who obtain subprime adjustable rate mortgage loans. So those ones that are below that 95%, right? $2 million worth of grants must be extended to establish 11 foreclosure education centers around the Commonwealth of Mass and promote first-time homebuyer and foreclosure counseling. Okay, so there's a lot of steps in place. Now, what is assignment of loans in this context? Lenders or holders of mortgages or deeds of trust often assign mortgages or deeds of trust to other lenders or third parties, right? So they don't keep the loan. When this is done, the assignee, the person receiving the assignment, steps into the place of the original lender or assigner. So you go to a bank, you sign all the papers with the bank, then the bank goes and assigns that loan to somebody else, okay? An assignment is a legal document confirming that the mortgage loan has been transferred from one lender to another. To make the assignment effective, the assignment must generally be in proper format and recorded to provide notice of the assignment. Assignments must be recorded at the Registry of Deeds where the property is located. So anyone who is researching the property's title may trace the loan ownership and origin. So this is kind of important because, again, back in the mid 2000s, they were doing a mortgage electronic recording system that got all messed up. So now you have to be able to follow the records. Okay. And a new requirement of the mortgage assignments to be recorded. Effective November 2012, House Bill 4323 substantially rewrote Mass General Laws, Chapter 244, subsection 14 and 35A, and added 2 entirely new sections. These changes added significant procedural hurdles to foreclosing on real property in Massachusetts. So under the new foreclosure laws, a foreclosure may not proceed unless the entire chain of mortgage assignments from the original mortgagee to the foreclosing entity is recorded. Okay, so no more MERS. Previously, the foreclosing entity had to possess but did not have to record the mortgage assignments before foreclosure. Okay, under the new law, no foreclosure notice will be valid unless that is done. Okay, So we talked about a deed in lieu of foreclosure, and I'm just going to jump in for a little longer here. So this says a deed in lieu of foreclosure is a voluntary way of surrendering or giving the property back to the lender without going through the foreclosure process, okay? It is still, for your credit purposes, considered foreclosure. The lender will often just consider a deed in lieu because it saves the time and expense of a foreclosure. The advantage to the homeowner is it avoids the embarrassment of a public foreclosure. Remember, it's going to be in the paper 3 times, right? And that is one of the things that most people are scared of, right? And they're afraid they're going to be embarrassed. They're afraid their friends or their work are going to see it, right? So the lender will not accept a deed in lieu if there is a second mortgage on the property, right? Because they won't get all that money. All right, so we're just going to talk a little bit about short sales. I told you a short sale is where the proceeds from the sale of the property provided insufficient funds to pay the existing liens and expenses related to the sale of the property, right? By definition, a short sale is a situation where the seller owes more on the house than they can sell it for in today's market. So it's short. Sometimes referred to as an underwater loan, right? So 3-party transaction. So it's always, if you ever see in anything saying subject to third-party approval, generally speaking, that would be a short sale. So it's the seller, the buyer, and the mortgagee, which is the lender. All right, and then some of the qualifications that you need for a short sale, right? Are they in default? If yes, how far behind are they? Is it more than one mortgage, right? If yes, it gets a lot more complicated, right? Do they have a home equity loan? Again, more confusion. Do they have PMI on their loan, right? Because a lot of times, you think about it, if the bank gives the mortgage, so for the first 7 years, they're just collecting interest mostly, right? And they have PMI on the loan, which means that they will be able to collect private mortgage insurance, right? So they foreclose on the property, they have PMI, so they would get the house, they get the insurance, they get the interest. So a lot of times, you know, the bank may just decide to keep it, right? Are they motivated and realistic? Okay. Do they really have, and then it says they really have to be broke. So if you have other assets, then they don't consider that it's a financial hardship, right? So, and also how cooperative will they be? They say the seller must be invested in the process. They're like, if your hardship letter doesn't bum you out, then you haven't written a good hardship letter, right? So how you got in the present situation? What was the hardship? You know, I just had something where the person had a brain aneurysm and lost his job, you know, or fell off a roof. Another person did. You know, what has changed in your life and in the residential real estate market since your original financing? And what have you done to try to get out of this situation? And is there really nothing that you can do to improve the situation? Right? Again, it says the lender doesn't care about you or protecting your credit score. So that's not the reason that you'd want to tell them you want a short sale, right? Again, it says here your hardship letter must show why granting your request is the best way, the only way to do it, right? And again, play on their heartstrings in a truthful, targeted manner. And I think this is what I was just saying. If you don't feel sorry for yourself by the time you finish that letter, then they won't, okay? So some seller options, payoff amount required by the lender is unacceptable, right? So the seller side rejection, right? So the amount that the buyer will pay, not going to work. Seller may consider bankruptcy after short sale closing, okay? So bankruptcy will stop a sale. Okay, so we're just going to, so those are a little bit of information for the short sale. Now we're just going to talk about government involvement in the real estate financing. All right, a mortgage that has no direct federal involvement, even though it may be a federally chartered lender, is called a conventional loan. Loans that have direct federal involvement include those insured by the Federal Housing Administration, or FHA, and guaranteed by the U.S. Department of Veteran Affairs, or VA. So those are the two government involved loans, okay? So what we're going to talk about is the primary and secondary mortgage marketplace, the role of the parties in each, and the impact of the parties through government influence. Describe the difference between conventional, government, and private loan mortgages available in real estate financing. Describe the various alternative and special purpose loan programs that can meet the borrower's special needs. And explain the primary government regulations which govern real estate lending. So we're going to cover those in this. So we are going to do our terms. So I'm going to scooch right through these. Again, you can stop if you are in replay and watch these. Okay. So again, in our introduction to real estate, we're going to talk about an introduction to the real estate financing market, some of those government influences. So that would be the Federal Reserve System. And then we're going to talk about the primary mortgage market and then the secondary mortgage market. All right, and you know what? I did not put the definitions in here, so you're going to just need to look those up yourself. The Fed regulates the flow of money and interest rates in the marketplace through its member banks by controlling the rate charged for loans, but makes those banks, and it makes to those banks, and it's called the discount rate, as well as their reserve requirements, the minimal level of funds that the bank must maintain. So the Fed, we always say if the Fed is getting loose, if there's inflation, then the Fed gets tighter or whatever, right? So you check the Feds. Now the primary mortgage market, this is the lenders make money directly available to the borrowers, okay? So that would be primary mortgage market. So some banks or some lending institutions could be savings associations, commercial banks, insurance companies, credit union, pension funds, endowment funds, investment groups, mortgage banking companies, and mortgage brokers. Okay, so that's the primary market. That's what we deal with most of the time. Now, you'll hear about the secondary mortgage market. Now, these are the people, when we had our crash, when we had the bailout, they funneled money into the secondary mortgage market to go help the primary mortgage market, basically. And it's loans that are bought and sold only after they have been funded. Okay, so again, we talked about that assignment. So this would be those assignments. And they would be through government-sponsored enterprises, okay, or GSEs. Fannie Mae, Freddie Mac, Farmer Mac, and Ginnie Mae. So those are in the secondary market. So that is important. They will try to get you FHA and VA, right? Part of our government involvement in the primary market. Secondary market, Fannie Mae, Freddie Mac, Farmer Mac, and Ginnie Mae, okay? So different loan programs, conventional, which is an 80% generally loan to value. So they put down 20% down and they go into a conventional loan, right? My favorite. Now there's the private mortgage insurance, a PMI, right? Is greater than the 80% loan to value. One of the reasons why somebody would want to put 20% down is that they would avoid that PMI, okay? Which is a private mortgage insurance that is paid on the loan when it's more than that. All right, FHA insured loans. Okay, so that would be, as I said, FHA insured loans. We just talked about the two programs, right? FHA and VA, right? So so the word that you want to know is insured on this one, right? So FHA is insured. That might be the question how they put it to you. Discount points, right? Those points are identified by the mortgage amount, right? Assumption rules. Now this goes both ways, right? So is this mortgage assumable by another person? Okay. And again, the new book expanded on assumption, right? And then HUD home sales. So if HUD owns the homes, they do the HUD home sales. And this is, again, has a lot to do with the secondary market. Now, so for FHA, the word was what? Insured. Now for VA, it's guaranteed. And they do certificates of reasonable value. So they have a little bit more of a CMA type appraisal type thing. They dig deeper. And how they dig deeper is they look for the costs that it might be to upkeep this house. So like a VA loan can have no peeling paint, right? Now there's prepayment privileges and there's also assumption rules, right? Now you can only have one VA loan at a time and there is no PMI on it, okay? That's why they like them. Now agricultural loans, okay, around here they're called USDA loans, all right? They're given out by the Farm Service Agency and the Farm Credit System. And these can be up to 100% financed. All right, other financing techniques are package loan. And again, you can read your definitions on these. For our purposes, they will be by definition. You really don't need to know a lot about these. Package loan, blanket loan, wraparound loan, open-end loan, construction loan, sale and leaseback, okay? A lot of times done in commercial, buy down, okay? And then home equity loan. So those are some terms that you will find out, when you go through those definitions. So different financing legislation, we had talked about some of them, the Truth in Lending Act, right, and Regulation Z. So this came Dodd-Frank, and then came the Truth in Lending Act, right, and Regulation Z. And that had to do with full disclosure and transparency from the mortgage companies to the consumers on what they were doing, what they were paying, what the closing costs were, all that kind of good stuff. Now, the Equal Credit Opportunity Act, okay, was part of that, where, again, it had to do with equality. Community Reinvestment Act of 1977, which is CRA, that had to do with going back into different communities, and even now we have opportunity zones, right? Real Estate Settlement Procedures Act. Again, this is the statement that shows everything on it, okay? And that was RESPA. It also said there was a whole bunch of items that like mortgage companies could no longer do, okay? Is I guess the best way, limits that they could do. Computerized loan origination, again, so there's a system that will go through and it will come out with the value, like the underwriting part of, as it says below, underwriting, automatic underwriting and scoring. So there's a bunch of systems in place now where there's a computer that goes through it. Again, oftentimes it's been assigned to a person, but the idea being that it cannot be wholly biased by a person anymore, okay? They felt that, that the mortgage people had too much freedom, essentially. Now we go on to state, right? We know that because it's red, right? So lender specifications. Lender Freddie and Fannie Mae have regulations that may prevent a sale, okay? Now tax issues that come up. Deficiency statement signed by the seller. Okay, I'm sorry, this is back to the short sale stuff. So deficiency statement signed by the seller. The 1099 form forgiveness of debt is taxable income. Okay, so this is back to short sale. So I'm sorry, this jumped in the middle. CPA advice recommended to the seller. All right, lender has sole discretion whether to cancel debt or take action to collect the difference between the amount owed and the amount collected. So this is what I talked about before, right? So there is no black and white on what the responsibilities will be or whatever. So what if a short sale fails? Now, even when a short sale is going on, they're running the foreclosure race over here in the bank, and then they're running the short sale race over here. So I've seen a foreclosure happen the day before a short sale was supposed to close, right? So they just don't care, and the bank does not communicate. All right, again, paying the past due amount, can you do it? An ability to request a modification. Other options that deed in lieu may still be available. The homeowner must deal with the bank on their own, right? So we try to help. We do try to help as much as we can, but again, a lot of times we got to get that homeowner involved. Now the foreclosure auction, and by the way, we also get lawyers involved. Like there's a couple of people who specialize in this. And then the foreclosure auction is the next step. Okay, so some of the legislation on this was the Mortgage Debt Relief Act of 2007. Now, Massachusetts does not recognize that act because we have our own. Now, that expired on 12/31/13 unless extended by Congress. And I do believe it was extended by Congress, but it's no longer in place. All right, so we do not have those protections for our consumers at this point in time. Okay, so that is it for right now for this financing, mortgages, short sales, foreclosures, legal title, lien theory, title theory. There's a lot packed in here. So this is one that you're going to want to watch a couple times and go through and really get really secure in your definitions, okay, and your understanding. And this is something that will be used. Okay, so I'm going to, let's just stop this and say goodbye to you. Okay, so goodbye. I hope that this was helpful. Please type us in, let us know any questions that you may have. We're always here for you, and we are so glad that you're here with us. Thank you. This is Kate Lanagan MacGregor. Goodbye.